Thank you. You may be seated. Welcome to the First District Court of Appeal. We have two cases on our docket this afternoon. We'll take them in the order in which they were listed. The first case is case number 24-0574, Kennedy versus Pearden. Appellant's counsel, when you're ready.
Yes, Your Honor. May it please the court, Dinah Stein on behalf of the appellants, Dr. Kennedy, the MDPA, and Gynecology Solutions, and we would request 5 minutes for rebuttal.
Noted.
Thank you, Your Honors. And of course, we're here today asking for a new trial on all issues from following the jury's $4.5+ million verdict in this medical malpractice case. And I'm going to start with going back to the opening statement when defense counsel made a representation and promise to the jury regarding plaintiff's key expert witness, Dr. Jameson. He said, you're going to hear that his opinions are his. They are not supported by the medical literature, in other words, the medical community. It was after this opening when plaintiff's counsel objected to any kind of cross-examination of Dr. Jameson in this regard. Now, I'm going to address plaintiffs because plaintiff puts a lot of energy on appeal on this.
Did they object during the opening?
No, Your Honor, there was no objection.
And there was no motion for mistrial that they were misled or somehow buffaloed into making this statement and then having it taken away from them.
There was no motion for mistrial. There was neither an objection by plaintiff or a motion for mistrial in this regard because it followed with argument.
So that has to be, you have to prove fundamental error then, right?
I would disagree, Your Honor, because we still have the issue of whether or not the limitation on cross was even appropriate. And that's what I'm going to get to. And that's really the issue. I mean, that's the issue that was raised starting with this framework. The initial objection by plaintiff was reverse bolstering and, contrary, it violates all the rules of Florida law. That was the objection initially, to which counsel was told to go home that night and research it. So the next morning.
So an expert can't bolster their testimony by bringing in a bunch of treatises, correct?
That's not on direct. You're absolutely correct, Your Honor. We agree. Or redirect. And this was never an issue with direct. This was never an issue with bolstering at all. In fact, the objection was reverse bolstering. And the discussion the next morning was, does this even fit within the framework of 9706, which talks about what an expert can do on direct and redirect? With the defense came armed with the Dust versus Garcia case, which we've discussed in the brief, and said, this doesn't fall within the framework. This is not an issue of bolstering. I'm allowed to challenge this expert's testimony.
So with that, it's more of a 705 issue, right, than a 706. I mean, 706, if you're going to use literature and such, then it's got to be authoritative, and so none of that really came into play here. This was more about, what's the basis of your opinion? Is this just purely conjecture, or is there something underlying an expert opinion? Is that correct?
To some extent now, and I'll respond by saying this wasn't exactly a causation opinion. It was to challenge his quite bombastic testimony regarding standard of care. And the cases that deal with this deal with it under various statutes. Some of them talk about it in the Daubert context, some of it, which was discussed below, some of it talk about in just the 9618 context. But
what would this have been probative of? What do you prove if there's no literature out there?
This is what it's probative of. And now I'm going to go to his Dr. Jameson's.
Because the converse is true also, that there wasn't any literature opposing the opinion or supporting the opinion, right?
Plaintiff says that in the brief.
Well, the judge says it too. There's no literature whatsoever on this particular that we know of.
That we know of. The judge, there was nothing proffered. What plaintiff said to the judge, and I think I would like to respond to that. The plaintiff said, I'll just say that if I was to ask the defense expert that, there would be no testimony either. And the court said, well, let's, suppose. He pondered it. There was no proffer, and what defense counsel said was, It doesn't matter. If that's the case, then let the chips fall where they may. But this is classic cross-examination that I'm allowed to do to challenge testimony, which, in response to the other question, what exactly are we challenging? Well, Dr. Jameson was very, very emphatic about his standard of care testimony on his opinions. He used words such as unconscionable. He said things like unfathomable, incredible, and we're not taking a position on appeal they were improper. He was allowed to give his opinions. We were allowed to come back, defense counsel, and say, well, who says that? Is that the medical community or is that Dr. Jameson?
Well,
That's
did the court's ruling prevent you from doing that? How narrow or broad was this ruling? My sense is this all took place in the context of medical literature, which seemed to keep it open for you to say, well, what's the basis for it? You say it's unconscionable. What's the basis for that? Did you rely on medical literature for that opinion? You could ask maybe something like that.
He was certainly allowed to maybe ask a broader question, but in that context, he came prepared for a very specific question. That's what the defense had prepared for based on his deposition testimony to show that this is not something that's recognized by the medical community. And to that point, the plaintiff's counsel asked our experts about, well, what have you done? Our expert and Dr. Kennedy, have you done this surgery within 2 days of, an incision and drainage? So obviously, he felt that inquiry or at least situation was relevant to the issues. But defense counsel's proffered cross was a little more to the point in, well, what literature can you identify that deals with this? Now, the judge really analyzed, how relevant he thought it was, and that's where we take issue again. And it's hard to know if he was just looking at it in a 706 context or relevance.
Well, he also
Either way,
talks about unfairness, so is there a more prejudicial than probative issue too?
he did the baseball example that if, and he came up with a hypothetical of somebody getting hit in a baseball game and not getting the brain scan. He had a very specific hypothetical, and his point was, you're never going to find anything that's exactly on point with whatever's before us, so what do we do with absence of literature? And that's where defense counsel came back and said, this is classic cross. If in other words, if an expert is prepared to defend his or her own opinions, they could come back and say, no, not under these facts, but there's plenty of literature that says you don't do surgery following this. That's our point, is that this is always something that a seasoned expert can deal with. If there's literature defending just general principles of medicine, they're allowed to, respond and cross and say that, but it's.
So Duss is your best case then that supports your proposition, although at trial, your counsel for the defense acknowledged that it wasn't directly on point. If that is the case, then, even though it's not directly on point, how can you say that no reasonable trial judge would reach the same result that Judge Duncan reached here?
I'm going to first respond that I do not believe Duss is our best case. I think it's our best case for saying that this is not within the framework of 9706, but our best cases are ones like Flores, Dempsey, Young Chin, the ones that talk about how prejudicial it is to not allow a lawyer to challenge opposing counsel's expert on cross, and the ones that say then in particular it's important with an expert because they're the ones who come into court who are allowed to rely on things like their training and knowledge. They are allowed to rely on predicates that are not necessarily admissible. So the jury hears experts come in, and it is particularly important to allow challenges to the very basis of their opinions. Those are the types of opinions that should have been allowed in cases such as Young Chin, Dempsey, Flores, and was the exact point that Mr. Kehoe, the defense lawyer, was trying to make to the court of, this isn't a 706 issue, this is just classic cross-examination for us to come back and, challenge the opinion. Again, this was the plaintiff's lead expert, and he was he came out with some very extreme opinions regarding the care and treatment in this case.
But it seems like, and let's say you're correct, that the judge should have let this cross-examination in. The cross-examination, it's a broad principle under Dempsey and some of the other cases. But it seems like both the experts and the doctor herself sort of all agreed that if you can see the cyst, that's what it comes down to. If you can see the whole thing, and then you can go at it. And what the opposing expert was saying is that you couldn't have, that it was basically a jelly, and it wasn't a hole. So it was sort of a credibility call between experts, because they all basically agreed on the science or the medicine underlying it. So why is this not harmless?
Well, no, I agree with Your Honor and believe that's what makes it harmful, is that it is a credibility call. That Dr. Jameson was taking this position that there's, well, first of all, the lack of literature had to do with just the doing the incision at all, the surgery at all 2 days after the incision. So that's what the the impeachment was about. And that's where he came out and said comments like unconscionable. And I'd be remiss if I didn't just address this in the context of damages as well, because the jury is now hearing really what his opinions are implying with words like unconscionable and incredible and unfathomable, are that no reasonable doctor would ever do this. I mean, that's what he's implying. We couldn't take issue with that. And I will just say, we propose why these are very extremely high damages, not to minimize the Puritan's injuries at all, but these are the types of damages you see in much more serious injury cases. It is much more than what plaintiff's counsel asked for in closing argument. And so I would submit, number one, these damages are just extremely high. They are manifestly excessive. I do believe that
So
they
we had a jury of 6 people, and they heard all the evidence, and they rendered a verdict and rendered damages, correct?
Correct, Your Honor.
And you want us 3 to say that they got it wrong and they
Well-
were too high, and substitute our judgment for that of the jury?
No, Your Honor. And there are 2 parts to our argument. One is excessiveness manifestly, and the other is that the jury was unduly influenced by the inability for defense counsel to challenge these very extreme opinions, which is what likely led to the damages being this high. So we have asked alternatively for a new trial on damages if we didn't get a new trial on liability. I am going to, if it pleases the court, reserve the remaining time for rebuttal. Thank you.
Thank you, counsel.
Good afternoon, Brian Gowdy on behalf of Mr. and Mrs. Puritan. On the damages, I agree with you, Judge Roberts, and I wanted to just correct what my friend said.
Well, that was a question, not really a statement.
Well, I agree with the sentiment of the question, that it's not up to you 3, it was up to the 6 jurors. We're dealing here with a young married couple that will have a lack of intimacy for 50 years. The jury heard that. And I want to correct what was said about the closing. What plaintiff's counsel said is to give at least $1 million for Molly and at least $500,000 for Bo, and then said, and this is on page 824, just do what you think is right. If you think these numbers are right, we'll accept it. If you think they're too high and you want to give us less, we'll accept it. If you think they're too low and you want to give us more, we'll accept it. So it's a mischaracterization of the closing to say that the 1 million and the $500,000 were somehow the ceiling. It was clearly left to the jury's discretion. I want to get to, on the harmless error that you brought up, Chief Judge, neither side filed the competing expert's deposition in the record. You won't see that. What happened was proffers by both lawyers. We've included in the appendix the entire discussion of this issue. And so the defense trial lawyer said, if I ask Dr. Jamison, is there any literature, he'll say no. And then a few pages later, the plaintiff's lawyer said the same thing about Dr. Philpott. It's on page 211. And the trial judge accepted both lawyers' representations. Neither lawyer below said that representation of the other lawyer was wrong. The trial judge made a finding, and I will tell the court, I have personally reviewed the depositions, and as you would expect, both the defense and plaintiff's lawyers told the truth about what those depositions said. But if we have a problem with harmless error, their entire appeal is built on a proffer, not on a deposition that was filed in the court. Neither deposition is in this record, and they bear the burden for the appeal. So if we can't establish harmless error, they can't win on the first issue if you're going to insist that the deposition be filed. But if the court wants the deposition, we'll file them. And plaintiff's counsel said the truth, and so did the defense lawyer about what the expert said. Getting to the heart of the first issue, Your Honor, I want to go to page 8 of the reply brief. The trial court, and this is what my friend says on the other side, with which I agree. The trial court's ruling was specifically focused on section 90.706. The trial court held that the rule, by implication, does not permit impeachment based on an absence of literature. I agree. It was on page 213. The trial court construed 90.706. And as we've pointed out, there's no argument in the initial brief why that construction was wrong. And we can go through that statutory construction that the trial judge did, but if you don't examine that in the initial brief, you haven't challenged what my friend said the trial judge specifically focused on.
As I hear the argument is this is black letter cross-examination law, that conjecture just
Right.
isn't protected from sitting there and not being challenged at all. What's the basis for this opinion?
Right.
You say it's unconscionable. What backs that up? Is that just you, or what's there?
Yeah, so now you're getting to what is the next sentence in the reply brief, which he says, my friend says, even if the trial court was correct in this holding, this does not impact the broader evidentiary principle that limiting the scope of cross-examination in a manner which keeps it from the jury relevant and important facts bearing on trustworthiness of crucial testimony constitutes error. And that I do disagree with, Your Honor, because the rules of evidence, it's not just good enough to show something's relevant, important, and crucial. If that were the case, then every piece of hearsay would come in. Not every piece, that's overstatement, but many pieces of hearsay could come in if they were relevant, important, and crucial, but they don't. Why? Because in the way the rules of evidence are set up, we have two types of rules. We have rules of inclusion and rules of exclusion. So 90.402 is the rule of exclusion. All relevant evidence is admissible. But then it says, except as otherwise provided by law. And the very next rule, 90.403, tells us relevant evidence is inadmissible. Why? If its probative value is substantially outweighed by unfair prejudice.
So is it your contention then that if we disagree with you on 706, that we could still affirm based on 403?
Yes.
Is that what you're getting at?
Yes. There's to the judge, and it's in the appendix, we put the whole colloquy. Plaintiff's counsel specifically cited 90.706, 90.403. The judge specifically said, we quoted on page 213, how he read 90.706. Now he didn't chant 90.403, but he was clearly in that whole colloquy doing the weighing that trial judges do under 90.43. So I think under either basis you can affirm, yes. And I guess just get back to your broader point about, yes, there's these cases that say, you can cross-examine, and like the defense has pointed out, some of these cases deal with, witness bias, for example, where, in one case that they cite is a criminal case where the defendant didn't get to cross-examine the victim about a civil lawsuit. But, Your Honor, here, well, just to give you another example is how I think this plays out. If you go to 90.608, okay, that actually is another rule of inclusion that deals with impeachment. And there's 5 categories of evidence listed there that you can impeach by. I won't go through them all, but they have things that you would expect, like inconsistent statement, bias, character by reputation, or convictions. Now, does that mean you get to bring in every single conviction? No, because we have 90.610 that uses the same permissive language that we see in 90.706.
Could the defendant here have asked this witness whether he relied on medical literature to support his opinion?
Actually, Your Honor, they could. I don't agree with that. I think that, and this is where there's a little bit of a disconnect between federal and state law, okay? I think that's an appropriate question at the Daubert stage. That's not in a question unless they're going to set it up under 90.706. And I also think that would be, what you just said, would be permissible under Federal Rule 803.18, which is different than Section 90.706. Our rule in Florida is very limited on literature when you're at trial, as opposed to, you said 90.705, in the Daubert rules, you are allowed to get into the literature. But the way 90.706 works, Your Honor, is it permits impeachment by literature subject to 2 conditions. 1, it's in cross-examination, and 2, the literature is authoritative.
Yeah, it seems like that 706 just doesn't even apply here. I mean, that they weren't ready to do that. They didn't claim that they would have any authoritative literature to cross-examine on. So we're not really talking about 706, it doesn't seem.
Right.
But the 705 idea of, do you have to let conjecture just sit out there? This is unconscionable. I can't even ask what the basis for that is.
Right.
I
Well,
can't ask, does that come from medical literature? Does this come from your experience? Where does that even come from?
Right. Well, first of all, they haven't argued 90.705 in their initial brief.
Well,
or
I guess
their,
I take their argument to be basically, they're asking, we weren't allowed to ask the basis of this opinion, so this arguable conjecture, this is unconscionable. Well, says who? Says
Well,
you. Well,
okay, as far as, if I could just, a couple things. I think, to be fair, you have to raise the ground to the trial judge, which that was, 90.705 wasn't raised. And then you need to raise it in the initial brief. But then I want to bring about this unconscionable. The unconscionable comment was not made in the deposition. So when you look at the appendix where all the argument happened on this preceded Dr. Jaminson's use of the word unconscionable, which he only did twice, not, if you want to call that repeatedly, but he only did twice. And he only did it once in regard to the opinion we're talking about, okay? But so they never came back to the trial judge, and an objection doesn't have to just be made, it has to be contemporaneous.
so you can see that that might have opened the door to them to go down this road.
They could have said, Your Honor, now that he said it's unconscionable, we should be allowed to go into this. They never went back to the trial judge. Just temporally, please keep in mind that the unconscionable comment came after the argument that's in our appendix. It was not made in a deposition. It was not proffered. So if that's important to you, well, then they should have gone ahead and brought that back up to the judge. They didn't. And that's really our argument on the unconscionability. It's not abandonment like the 90.706, which is, on appeal you've abandoned something. It's that they didn't make a contemporaneous objection once that comment was made. We're not saying they had to move to strike the testimony, but if they believed that comment changed the admissibility analysis, well, that comment hadn't been made when the argument was being before the judge, before testimony. And it was incumbent upon them to say, now the door's been opened, and they never did.
But whether it was unconscionable or whether it was even a more watered-down rule, they could have followed that up by saying, well, what's the basis of that opinion? What facts and
They
data
could
points
ask
to
that. I agree with that. That's different, though, than the question they wanted to ask. They wanted to say, isn't it true that no literature supports your opinion? That's different, and it's different because, frankly, Your Honor, we have this 90.706, and I know you just said a moment ago you don't think it applies, And I guess what I would tell you, I've really looked closely at all this case law, and I think you really have a novel question in front of you, but no briefing in the initial brief on it. Because the way the trial judge, he disagrees with you, okay? He construes 90.706, sort of like I was trying to get to a minute ago with 90.610. If you don't show if you don't show a felony conviction or a crime of dishonesty, you don't get any other conviction in to impeach. It uses the same may language, it's permissive language. He said, look, this statute tells us how we can use literature at trial. And there's two conditions, cross-examination and authoritative. And the judge said, it's not authoritative. And they haven't challenged that on appeal. So now, if you look in Florida case law, there are lots of opinions dealing with using literature on direct or redirect. And again, you would say, well, 90.706 doesn't apply, right? Because it talks about cross-examination. I think that's your rationale, Chief Judge. Well, what the courts have said, and it's in the Professor Earhart's treatise, is that it's implied that if this is the rule that it's for, you can only use it in, it says cross-examination, you can't use it on direct. And so that's where the whole bolstering rule comes from in part, as well as I think also from the hearsay rule. But there's no rules, there's no statute that says that bolstering rule. The courts have engrafted that on using basically Scalia and Gardner's negative implication canon, section 10 of their book, to say, hey, if it says you have to meet these two conditions to admit this testimony, or it's not admit, to use this testimony. It doesn't even use the word admit, it uses use. Well, then if you don't meet those two conditions, you don't get to use literature. And if you look at the Janoff case, right, that we cite, and the Dust case, those are the only two decisions in Florida. I mean, you go through all these cases that I have that are cited in these briefs. Those are the only two that deal with lack of literature. Okay? And they were both on, they're distinguishable, I concede. They're both on direct or redirect. They're not on cross like here. And in Janoff, it was the treatises they were relying upon were considered authoritative, but the third DCA said, well, we're not going to allow it because it's not on cross-examination. And again, I think using the negative implication canon. In Dust, by contrast, I just want to quickly make this point because I'm running out of time. And my firm handled Dust. The big thing there was that it was widespread that vacuum extractors were used in baby deliveries. And so what the expert on direct for the defendant said, it's so widespread you'd expect to see some literature making this causal link. And the absence of literature is indicative. Well, in this case, if I could have just finished the sentence.
Yeah,
that in this case, Your Honor, Dr. Philpote testified that he had never experienced an IND being done 2 days before a surgical excision. That's their expert said that. Dr. Kennedy said she had not done it other than in this case. And Dr. Jamieson said it's never done. So unlike
this procedure was fairly rare. It was like 5 within a couple.
well, well, there's two rarities. One is doing this surgery was rare, but then even the only case that we even know of that somebody doing an IND and then 2 days later doing this surgery is Miss Pearden. So unlike in Dust, where it was a widespread practice, then you would expect literature, and this is what the trial judge was, I think, getting to. This was so rare, you wouldn't expect any literature. There's no known case of anything like this happening other than in Miss Pearden's case, meaning you do an IND, and then you have a short delay, and you go to the surgery. There's none. And Dr. Phillips, their expert said he had never experienced that. And that's transcript 420, lines 2 through, transcript 696, 25 to 697. And so I appreciate the extra minute and hope you give it to Ms. Stein. Thank you.
Thank you, counsel. And let's add a minute and a half to appellant's time.
Thank you, Your Honor, and I'll try to keep it brief. The only novel argument below was plaintiff's position that 9706 doesn't allow lack of literature discussion. What is not novel is the longstanding case law, and again, this is just from Dempsey, the holding that cross-examination of experts on relevant and material issues is especially important in view of the rules of evidence that permit experts to testify and express opinions without setting out in detail all of the predicates upon which their opinions or testimony may be based. These matters are now largely left to be explored on cross-examination, and it goes on. So this is a very well-settled principle.
Would you agree that the 705 argument wasn't made below? There wasn't a mention during this whole discussion of 9705?
There was very little discussion of the statutes at all. We were,
Well, I mean, 706 was discussed.
706 was
But it
discussed.
may not apply at all. But
Right.
705 wasn't discussed, even though it may conceivably apply.
And I don't believe 705 is discussed in this particular opinion either. And I guess my point being that these are based on evidence rules which are, or statutes which are really codifying the foundational rules. We all know what's being talked about. We all knew that the court was discussing whether this could be, I guess, the rarity of this. I'm not sure that the record said how rare it was, but he was just commenting on what may have been the relevance. But 705 wasn't mentioned either way, but defense counsel made clear this is classic cross-examination where I can challenge the expert's testimony and opinion. Just very, very briefly on some of the points as far as this suggestion of a lack of proffer, that's not raised in the answer brief. If it was, we could have addressed it. The cross-examination absolutely was proffered to the court beyond what was said in the deposition. It's not realistic. Dr. Jameson, I don't even know if he was there during the time it was all discussed, but you don't just, cross-examine an expert for a proffer. The proffer was made on the record. It was very clear, and we could have made this clear if it had been raised. I believe plaintiffs have waived that argument. The court never did a 9403 analysis. I don't believe. There was no finding on the record as far as just undue prejudice. But if he did, we addressed it. Again, we said this is relevant. The jury's not going to be confused by this. The only other point I just want to respond to is this concept that the unconscionable comments should have been a door opening, perhaps, issue. The proffered cross was to his entire testimony. The unconscionable comments are icing on the cake. They make it that much more prejudicial, but there was nothing about the court's ruling that was going to suggest that we could come back and say, change your mind on what you believe 9706 says. So we submit there was a very definitive ruling made. The unconscionable comments did not suggest we should come back and ask the court to change his mind. He had made a ruling, and that's certainly not a waiver under these facts. So again,
Why don't you think that even despite the judge's ruling, that you still had plenty of room to examine what's the basis for your opinion?
well, we were allowed to examine the basis, but we're talking about an opinion that is based on his experience and training. So aside from saying, well, where do you get this from? He's saying he's never heard of it. Well, then all we have is, well, is there a consensus in the medical community that this is unconscionable wrong? I mean, under these facts, this is how you challenge his opinion, by saying, is this supported in the medical community?
Or Daubert.
The literature. We were not, well, and that's what defense counsel said below. We were not moving to exclude him as unreliable or unqualified. This is not a Daubert issue, which again, this Earhart and these cases say Daubert usually yields to vigorous cross-examination. In fact, it's rare that you would keep an opinion out. We weren't trying to keep his opinion out. We were trying to challenge it, as Earhart and these cases suggest, with vigorous cross-examination, asking what supports your opinions. So we don't believe it was a Daubert issue, and we made that clear below and on appeal. So again, we thank your honors for the time, and we would request a new trial. Thank you.